Is presenting a backpack for a canine sniff a search under the Fourth Amendment? Hey guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another roadside chat. This question comes from an officer in Texas. He said, "All right, so would it be a trespass on a backpack if you took a backpack off a person and directed that a canine sniff that bag, right? Also, what if the handler directed the canine to scratch the backpack? Would that be a trespass and implicate this case called Jones?" Okay, so let's get some ground rules here and figure out kind of like what's being asked here. Number one is Illinois versus Caballas, U.S. Supreme Court, 2005, I think. But what the U.S. Supreme Court said there is that just sniffing something with a drug dog is not a search under the Fourth Amendment. Okay, a couple reasons. Number one is that there's no trespass. There's no physically touching the motor vehicle in this case. And number two, there's just no privacy interest in odors that are like leaving a vehicle and contain narcotics. There's no privacy issue or interest in illegal substances. Now, of course, if your state legalizes marijuana, then they have a privacy interest in that because it's not contraband anymore under the state law. But the point is, that's the first thing. There's just no privacy interest in sniffing. The second thing is that Jones, U.S. versus Jones, is a U.S. Supreme Court case talking about this idea that when police intentionally interfere or trespass, and intermeddle was actually the right word, but when they intermeddle with a person's property, their car, their backpack, their person, with the intent to gather information, that is a search under the Fourth Amendment. There's two searches. There's privacy and trespass. A person may have a reasonable protection of privacy, and that could be a search. So, for example, when it comes to drug odors, I already said there's no privacy interest, but you still have to consider whether or not there's a trespass going on. So, for example, I have been teaching for many, many years that if you direct a drug dog to jump up and climb onto vehicles, climb into truck beds and so forth, that is a search, right? Maybe not under privacy, but under trespass. The dog is your conduit, is your government property, and by intentionally directing it to touch the vehicle that is seeking information, that is a search, okay? So now, the next question I have for you, or ground rule, is what about you removing a person's backpack? When police basically order somebody to remove their backpack and put it on the sidewalk, or they take it off the person, that is a seizure under the Fourth Amendment. That case is Jacobson, where the Supreme Court has said when police intentionally interfere with a person's possessory interest in their protected property, that is a seizure under the Fourth Amendment. Okay, now that we have those ground rules, let's apply them here. So clearly, taking off the backpack and putting it on the sidewalk, is a seizure because the person did not, give you consent to do that. If they got consent, that might be something different. But here, let's say that there's no consent, but you can do it with reasonable suspicion. Okay, you can seize property like a suitcase with reasonable suspicion. That case is Place, PLACE, U.S. Supreme Court, where you can seize property temporarily if you have reasonable suspicion and submit that item to a drug dog sniff. Okay. The second thing is if the handler is intentionally commanding or instructing his dog to physically touch that bag, that's a problem. Now, the reality is that, I've taught many, many handlers over the years. I don't ever see handlers doing this. Handlers are not going to instruct their dog to scratch at a backpack just for, just to do it. There would be no reason for that. That's not how they're trained. If the dog scratches, it's because if it's an aggressive, alert dog, the scratching is the alert. It's the final response that they're trying to train these dogs to do. But we're good there because even if the dog is physically touching the bag, and yes, we have taught it to do that when it has that final alert, but that's exactly what we want to do because we have probable cause. See, before the scratch occurs, when that dog intentionally scratches in order to let its handler know that it's done finding the narcotics, well, the dog has, the handler has probable cause, right? Because the dog is doing exactly what it's supposed to do when it actually senses contraband. So that touching would be a search, but it'd be a lawful search because you would have probable cause at that point. And you still need a reason to open the bag. You would have to have search, incident to arrest. You would have exigency. You would have to have, a warrant. You would have to have something else, right? I'm not saying you can open the bag, but the scratching would not be an issue. And okay, so that's that. So we have we can put the bag on the ground. The sniffing's not a search, but it can be done with you can detain the bag with reasonable suspicion. We have all that, and of course, the way that the dog alerts to the bag is also not going to be an issue. So there's your answer. I hope this helps. If you have any questions for us, email us at go to bluetogold.com and contact us, or put a comment below. That's another way that hopefully we'll see your comment. If not, the direct way is bluetogold.com. If you like what we're doing here, please like, subscribe, share with your friends. Until next time, my friends, you stay safe.